Madam Speaker, a few questions to the proponent, if I may.
Please proceed.
I voted no against this in committee and are hoping that the good chairman can answer some more questions because I am still open as I take my final vote. Section 1, line 1 says, prior to sentencing, through you, how far in advance of sentencing must the judge review this impact statement?
Representative Fox.
Through you, Madam Speaker, it does not say. I mean, I would presume, and I've seen it all different ways. Sometimes defense counsel will submit something to a court in writing a week in advance, several days in advance. Sometimes they do it the morning of sentencing. And that's not necessarily just a family impact statement. That's the letters and other items that I described earlier. Sometimes if it's a pre-sentence investigation, that can be reviewed a week ahead of time or a few days ahead of time. So there's no definitive time, and I would presume that defense counsel would try to get it to the judge within a reasonable time prior to sentencing.
Representative Carpino.
Thank you, Madam Speaker. If criminal defense attorney hands this report to the judge 15 minutes before sentencing is to take place, is the judge still obligated under this proposed bill to read it? Through you, Madam Speaker.
Representative Fox.
Through you, Madam Speaker, I believe the judge can simply say they considered it. I don't envision some of these being very long when you're talking about the family impact statement, but I think it just would be something that would make it clear to the court so that they are aware that this individual is a parent or guardian of a minor child that is in their custody, and incarceration, or whether it's any incarceration or a long period of incarceration, would have some type of impact on that child or children.
Representative Carpino.
Thank you, Madam. When we're talking about physical custody in line 5, is this solely full physical custody, or would a parent or guardian who has shared physical custody also be invoked in this proposed bill? Through you, ma'am.
Representative Fox.
Through you, Madam Speaker, I would think physical custody would be if the child is determined to live with them. So there are some situations where parents are divorced and there's an order of shared custody, and I would expect that in that case they could present a family impact statement because the shared custody arrangement, I presume, would show that this child is with them for whatever period of time the child is with them.
Representative Carpino.
Thank you. And when we're talking about a term of imprisonment, could it be as few as a few days, or as few as a couple of days, which would invoke this and again force our judges to read this impact statement and consider them? Through you, Madam.
Representative Fox.
Through you, Madam Speaker, I mean, it does say a term of imprisonment, so if there's a threat of incarceration, then I believe this can be submitted. I mean, oftentimes, you rarely see a sentencing argument where the worst that the defendant is facing is several days. Sometimes a court will try to send a message and sentence an individual to several days, but usually, at least at the time of sentencing, the danger of being sentenced to a greater period is there.
Representative Carpino.
Thank you, ma'am, and I thank the good chairman for his answers. I have no more questions for him, but I do have some concerns in this bill. We are forcing our judges to consider something that should be obvious. If we have a parent with a minor child that has physical custody, of course there are going to be implications. The parent should have thought about that before committing the crime. I'm also concerned about lines 12, 13, 14, and 15. If a parent has financial needs that are above average, the judge should not be considering that. If a parent has wonderful job opportunities or is a good parent, at what point do we stop treating convicted individuals differently? There will always be an impact to these children, which is very unfortunate, but we should not be tying our judicial branch's hands one more time. I urge my colleagues to think twice before supporting this. Thank you.
Thank you, Madam. Will you care to remark further? Will you care to remark further?